Welcome. If you're a foreign professional working in the United States or an employer trying to sponsor a valued employee, the H-1B visa is one of the most important immigration pathways you need to understand. I'm an immigration attorney at Prosperity Immigration Law based in Houston, Texas. Today I'm walking you through exactly how the H-1B process works in 2026, the timeline, the requirements, and what you need to do right now. Let's start with the basics. The H-1B is a non-immigrant work visa that allows U.S. companies to hire foreign nationals in specialty occupations. These are roles that require at least a bachelor's degree or the equivalent in a specific field. Software engineers, accountants, architects, physicians, financial analysts, and many others qualify. The H-1B has a hard annual cap. There are 65,000 visas in the general category, plus an additional 20,000 reserved for people who hold a U.S. master's degree or higher. That's 85,000 visas total for the entire country. Because demand far exceeds supply, USCIS runs a computer lottery. In fiscal year 2025, over 470,000 registrations were submitted for those 85,000 slots. That's roughly 1 in 6 odds. If you're not selected, you cannot file that year. Here is the annual H-1B cycle. USCIS announces registration dates in January or February. Online lottery registration opens in March. If selected, your employer files the full petition between April 1st and June 30th. If approved, your H-1B status begins October 1st, the start of the federal fiscal year. Miss any step in this chain and you've lost that year entirely. That's why starting early, ideally in the fall of the prior year, is critical. Now let's talk about what you need to qualify. There are 3 key requirements. First, the job must be a specialty occupation. USCIS requires that the role demands the theoretical and practical application of highly specialized knowledge. Not every professional job qualifies, and your attorney needs to build a clear case. Second, you must have the right educational credentials, a bachelor's degree in the specific field related to the position. If your degree is from another country, you'll need a credential evaluation from a recognized organization that converts it into U.S. equivalency. Third, your employer must be able to pay the prevailing wage for that position in that geographic area. The Department of Labor publishes wage levels by occupation and location. Getting this number wrong is one of the most common reasons petitions get challenged. Let me walk you through the most common mistakes I see. Employers submitting job descriptions that don't clearly establish specialty occupation. Credential evaluations that don't meet USCIS standards, prevailing wage determinations that are set too low, missing the registration window, even by 1 day, and not preparing a strong specialty occupation argument up front, which leads to costly requests for evidence. An RFE delays your case by months and costs money to respond to. Prevention is always less expensive than cure. Here's what you should do right now. If you're a professional hoping to be sponsored, have the conversation with your employer today. Give them time to evaluate the position and work with an immigration attorney. If you're an employer planning to hire foreign talent, start your legal preparation in the fall, not in February when the rush hits. And if you've been through the lottery before and weren't selected, don't give up. There are real alternatives. The O-1 visa is available for individuals with extraordinary ability. The L-1 visa works for intracompany transfers. And employment-based green card categories, EB-1 and EB-2, offer paths that bypass the lottery entirely for qualifying candidates. The H-1B process is complex, but with the right preparation and the right legal team, it is absolutely achievable. If you have questions, call us at 832-479-1833. We are Prosperity Immigration Law.